Thank you, Mike. And many thanks to the members of the Commission for having us here today. We are pleased to be here. I'd like to start out by talking a little bit about the Senate Select Committee on Intelligence report and then about our torture prevention efforts more generally. Last year, the Senate Select Committee on Intelligence asked the White House to declassify the executive summary, findings, and conclusions of their report on the CIA's former detention and interrogation program. President Obama determined that the report should be declassified, with appropriate redactions necessary to protect national security. He also supported and continues to support the committee's release of the declassified report. The committee released the declassified executive summary, findings, and conclusions to the public in December 2014. And in the interest of transparency, this public report is nearly 500 pages long. 93% of the summary report is entirely declassified. It details activities that took place under a CIA program that has since ended. The decisions following the attacks of September 11, 2001 relating to this former program are part of our history and are not representative of the way we deal with the threat from terrorism we still face today. One of the great aspects of our democracy is that we have the ability to look at our past and identify where we could and should do better. This report should be viewed as what it is, a recounting of a period in our history that has since passed. The United States upholds the bedrock principle that torture and cruel, inhuman, and degrading treatment or punishment are categorically and legally prohibited always and everywhere, violate U.S. and international law, and offend human dignity. Torture is contrary to the founding principles of our country and to the universal values to which we hold ourselves and our international community. I'd like to take a few moments to tell you about what we've done to prohibit and prevent torture going forward. First, as you know, 6 years ago, President Obama issued an executive order formally ending the detention and interrogation program conducted by the CIA. Immediately upon taking office in 2009, he issued Executive Order 13491 on ensuring lawful interrogations. He also directed the closure of any detention facilities operated by the CIA and prohibited the operation of any such facilities in the future. Second, the President mandated that, consistent with the Convention Against Torture and Common Article 3 of the Geneva Conventions, any individual detained in armed conflict by the United States or within a facility owned, operated, or controlled by the United States in all circumstances must be treated humanely and must not be subjected to violence to life and person nor to outrages upon personal dignity. This comports with the Detainee Treatment Act of 2005, a federal statute which requires that, quote, no individual in the custody or under the control of the U.S. government, regardless of nationality or physical location, shall be subject to cruel, inhuman, or degrading treatment or punishment. Third, the President directed that no individual in U.S. custody in any armed conflict shall be subjected to any interrogation technique or approach or any treatment related to interrogation that is not authorized by and listed in the Army Field Manual. The manual, which is publicly available, explicitly prohibits threats, coercion, and physical abuse. The United States confirms that the interrogation techniques in the Army Field Manual are binding on the U.S. military and are also binding on all federal government agencies, including the intelligence agencies, with respect to individuals in U.S. custody or under U.S. effective control in any armed conflict. This is without prejudice to authorized non-coercive techniques of federal law enforcement agencies. The Field Manual contains detailed procedural requirements that must be followed prior to the use of the listed techniques, including safeguards and a legal review. These procedural requirements help to ensure that the techniques in the manual are implemented consistently with the requirements that all prisoners and detainees, regardless of status, be treated humanely, and explicitly prohibiting cruel, inhuman, or degrading treatment. The Department of the Army conducts yearly reviews of the Army Field Manual to ensure that its provisions remain consistent with applicable law, policy, and practice, and to assess whether updates are needed due to evolving operational circumstances and lessons learned. In making public the manual's list of interrogation techniques approved for use during armed conflict, the United States has sought to demonstrate our commitment to transparency and accountability in this area. We welcome further engagement with civil society, and we will continue to promote a robust dialogue on these issues. Finally, last month, the United States announced that it would join the group of friends of the Convention Against Torture Initiative, the CTI, which is spearheaded by the governments of Chile, Denmark, Ghana, Indonesia, and Morocco. The group of friends of the CTI is a growing group of states, civil society, and experts in the field dedicated to the pursuit of universal ratification of the Convention Against Torture and to finding new and innovative ways to prevent torture globally. The CTI is now fully engaged in that effort, which includes a meeting in Costa Rica later this month to encourage more states in the region to ratify and implement the convention. I'd like to now spend a few moments discussing some of the actions that federal agencies have taken to investigate and punish torture and cruel, inhuman, or degrading treatment or punishment in the United States, and action to train interrogators to ensure humane treatment. I'll also speak briefly about our efforts to provide for rehabilitation of torture victims. As a preliminary matter, U.S. law provides several avenues for the domestic prosecution of U.S. government officials and contractors who commit torture and other serious crimes overseas. For example, 18 U.S.C. 2340A makes it a crime to commit torture outside the United States. Similarly, under the provisions of the Military Extraterritorial Jurisdiction Act, MIJA, persons employed by or accompanying the armed forces outside the United States may be prosecuted domestically if they commit a serious criminal offense overseas. In addition, U.S. nationals who are not currently covered by MIJA are still subject to domestic prosecution for certain serious crimes committed overseas if the crime was committed within the special maritime and territorial jurisdiction of the United States, which includes, among others, U.S. diplomatic and military missions overseas and the U.S. naval base at Guantanamo. The U.S. government has investigated allegations of torture or cruel treatment. Prior to August 2009, career prosecutors in the Department of Justice carefully reviewed several cases involving alleged detainee abuse. These reviews led to charges in several cases and the conviction of a CIA contractor and a Department of Defense contractor. Other cases were declined for prosecution by the Department of Justice for a variety of reasons consistent with the principles of federal prosecution. In 2009, the United States Attorney General directed a preliminary review of the treatment of certain individuals alleged to have been mistreated while in U.S. government custody subsequent to the 9/11 attacks. The inquiry was limited to a determination of whether prosecutable offenses were committed. The review considered all potentially applicable substantive criminal statutes, as well as the statutes of limitations and jurisdictional provisions that govern prosecution under those statutes. That review of the alleged mistreatment of 101 individuals was led by a career federal prosecutor and is now known as the Durham investigation. It generated 2 criminal investigations. The Department of Justice ultimately declined those cases for prosecution because the admissible evidence would not have been sufficient to obtain and sustain convictions beyond a reasonable doubt. Representatives of the ACLU and the Global Justice Clinic today raised the question of further investigations or prosecutions, as did the Special Rapporteur. As a general matter, the Department of Justice does not comment on ongoing investigations or plans to initiate future investigations. The Department of Justice and the relevant law enforcement components approach cases involving allegations of torture or detainee abuse in the same manner that they approach all allegations of serious crimes, by conducting a thorough examination of available facts, following those facts wherever they lead, and undertaking an impartial application of the law and the principles of federal prosecution. Beyond the Department of Justice, there are many other accountability mechanisms in place throughout the U.S. government aimed at investigating credible allegations of torture and prosecuting or punishing those responsible. First, the CIA Inspector General conducted more than 25 investigations into misconduct regarding detainees after 9/11. The CIA also convened 6 high-level accountability proceedings from 2003 to 2012. These reviews evaluated the actions of approximately 30 individuals, around half of whom were held accountable with a variety of sanctions. Even so, the CIA has acknowledged that the results of these efforts are unsatisfying in view of the serious nature of these events, and in some instances, it should have looked more deeply into leadership's decisions to examine what could have been done better and to determine what responsibility, if any, should have been assessed at a more senior level. Looking forward, the agency will ensure that leaders focus more on management responsibility and systemic issues when viewing and reviewing accountability. The U.S. military also investigates all credible allegations of misconduct by U.S. forces to determine the facts, including identifying those responsible for any violation of law, policy, or procedures. And multiple accountability mechanisms are in place to ensure that personnel adhere to those laws, policies, and procedures. The Department of Defense, or DoD, has conducted thousands of investigations since 2001, and it has prosecuted or disciplined hundreds of service members for misconduct, including mistreatment of detainees. For example, more than 70 DoD investigations concerning allegations of detainee abuse by military personnel in Afghanistan resulted in trial by courts-martial. Close to 200 of these investigations of detainee abuse resulted in either non-judicial punishment or adverse administrative action, and many more were investigated and resulted in action at a lower level. The remainder were determined to be unsubstantiated, lacking insufficient evidence, or were included as multiple counts against one individual. All courts-martial proceedings are a matter of public record. Convictions can result in, among other consequences, punitive confinement, reduction in rank, forfeiture of pay or fines, punitive discharge, or reprimand. Individuals have been held accountable for misconduct related to the abuse of detainees by personnel within their commands. These individuals include senior officers, some of whom have been relieved of command, reduced in rank, or reprimanded. Beyond these accountability mechanisms, training measures are in place to safeguard against torture and cruel, inhuman, or degrading treatment or punishment in interrogations. For example, DoD intelligence interrogations are conducted only by properly trained and certified personnel. Training includes instructions on applicable law and policy, lawful interrogation methods and techniques, the humane treatment of detainees, and how to identify signs of torture and cruel, inhuman, and degrading treatment, and the procedures for reporting violations. Routine refresher training is provided on a recurring basis. These are just some of the accountability and training measures in place in the United States to prevent torture and ill treatment and to ensure the credible allegations of torture or ill treatment are investigated. On the issue of rehabilitation, I'd also like to note that we support civil society organizations that campaign against torture and that treat its victims, and we are the leading donor of the UN Voluntary Fund for Victims of Torture. We also have a federal statute, the Torture Victims Relief Act, which authorizes funding for a number of programs that provide rehabilitation services for survivors who suffered torture, including funding for the Department of Health and Human Services to support treatment centers inside the United States and programs for the treatment of survivors who suffer torture abroad. Funding in fiscal years 2013 and 2014 totaled over $21 million. To conclude, I'd like to once again thank the Commission for the opportunity to speak here today and to turn the floor back over to you.